there sequestered by himself. What do you think about letting him be on call, give a phone number that he can be reached at to the clerk, and I'll just instruct him not to read anything or talk to anybody about it until it's over with.
We would object to that. I
Okay.
think that it would be more appropriate that at any given point, if something develops, that he be able to be immediately available and that he not be influenced during this period of time once the arguments have been made and the deliberations begin. We think that the better and wiser course would be to simply have him wait in another area until such time as we conclude this process.
Okay.
Okay. One last thing, Your Honor. We would make this in the way of a motion for reconsideration, and we recognize that the court has done a very thorough job in terms of researching the issue of nullification. However, I think that it's important that the court note that we at no point had ever raised to the court that we were engaged in jury nullification or were even seeking that as...
I brought it up first, so...
Yes. And so when we look back at the code section 16-3-20, official code of Georgia Annotated, we see several cases indicating that there is reversible error where justification is the only defense that the defendants have put forth. I'm looking here at Wells versus State, 200 Georgia Appeals, page 104, 1991, one case says, trial court's failure to charge the jury on justification as a defense to the crime of impersonating an officer was reversible error since the defendant's sole defense was justification. Okay? Another case, which was Smith versus State. It says, defendant was entitled to a jury charge on the affirmative legal defense of justification on the charge of failure to maintain a lane. A driving offense, not involving force, a driving offense, which was the defendant's sole defense. And since testimony could support that charge. And then there is another case. I'm not able to put my hands on it right quickly. There's a third case. So you've got three cases here in the court's materials that the court looked at and which court referred to earlier during this charge conference that seem to support the position that if that is the defendant's sole defense, and the court will recall what my opening remarks to the jury happened to be, the court will recall the line of questioning that was made to each of the defendants, that this was our sole defense. And so it would be, as I believe, if you have one decision in this annotation here that says that the failure of the court to give the instruction is tantamount to giving a directed verdict to the prosecution. So in this situation here, Your Honor, we believe that it would be that the defense has submitted for justification.
You wish to be heard on this, Mr. Brown?
I don't think that, I disagree with Mr. King. I've looked at all the subsections for justification. I don't see how it applies in this particular case. You know, I would ask the court to maintain its earlier ruling, Judge.
I still don't think that it's reasonably raised by the evidence. I mean, I don't think it's not the situation like the Moore case where the man had been pepper sprayed and he's in the back of the police car and he said he can't breathe, so he's got to break the window of the police car so he can breathe, or he's going he's gonna die. I mean, I can envision a situation where you would have to go in the illegal lane of traffic to avoid a car wreck. You know, that would be the defense of necessity. I still don't think here that we've got, I don't think it's reasonably raised by the evidence, so I will overrule and deny the motion. And I'll understand that your objection is, you've got a continuing objection as to that. All right, we're ready for the jury. And I believe the closing argument on the misdemeanor case is the parties are limited to 30 minutes each on misdemeanor cases. Isn't that rule known?
Your Honor, I would ask that there be given some latitude. We have 7 defendants that are on trial here today.
How long do you want to talk, Mr. Key?
Well, you know, I'd like to have at least the comfort of knowing that if I have to go an hour, that's fine. I doubt seriously that I will do that, but I would like to have that comfort.
All right, well, it's 11 o'clock, and we've kept the folks in the back here for an hour, and I told them 20 minutes. So, you know, so probably need to be mindful of our jurors' comfort. All right, we ready?
Yes, sir.
Okay. All right, bring the jury back. Everyone remain seated while the jury returns. I would think probably that when you guys get through your closing arguments, it'll be lunchtime, and maybe I should let them go to lunch and then bring them back and charge them after lunch, and then give them the case. Does that sound like a plan? Gentlemen? That sound okay, Mr. King?
Yes.
Okay. turned into an hour, but sometimes it takes lawyers 20 minutes to say their own name. So, but you are still hanging in there, I hope. All right, Mr. Brown, the state has a right to open and conclude.
Kendrick reserved all the time for last.
All right, Mr. King?
Yes. Good morning.
You want to wait just a second, Mr. King? I think Ms. Clary needs to work like that. Are you ready, Ms. Clary?
Yes.
All right, you have to.
Ladies and gentlemen, we are at near the final stage of this process called a trial. As you may recall, initially, I appeared before you, and so did Mr. Brown, to basically give you a roadmap as to what we thought the evidence was going to show you during the course of this trial. And you have sat through approximately a day's worth of testimony. You've heard from a number of witnesses. Most importantly, you have heard from the individuals who have been accused of violating the law and who are before you at this time maintaining their innocence. Before we go any further, it of course is my duty to, on their behalf as well as my own, express to you our appreciation for the time, the patience, and the attention that you have shown throughout this trial. The jury system is perhaps one of the fairest systems of law that man has ever known. It allows individuals who come from a community, who are the peers of the folks who have been accused, to sit in judgment and to decide the case for themselves. And that is so essential to our concept of fairness in this society. So we don't at all want to ignore the significance of your participation in these past 3 days, sitting here, giving of your time and maybe expense to come to this courtroom to perform a civic duty. And that duty is one that you perhaps heard mentioned during the course of this trial, and that was a search for justice. Now, I don't want you to at the same time diminish the gravity of what we've been engaged in simply because my clients are charged with misdemeanor offenses. Justice, as I believe we talked about during the jury selection process, is uniform. It is the same no matter if we were trying a case in which somebody was charged with a felony versus a misdemeanor. It it wouldn't make any difference if you were talking about trying to seek a divorce versus get a recovery or an injury sustained. And it certainly would not matter here, where you have heard the testimony of a family that was in search of one of the most precious things that you and I will ever know, and that is the truth. Now, let me, before I go much further, just think a moment outlining for you what I believe we have seen here in these past few days. I told you at the outset that this family maintains that they're innocent because they were justified in taking the action that they did. Not in the sense that they engaged in the destruction of property or some violent act, or that they took from somebody something that was of value, albeit it may have caused an individual to be inconvenienced only but for a minute or two. But that they felt that they were justified and that it came about only because they had no choice. No choice. Think of it. Your child goes to school and doesn't come home that evening. You're a mother who works for the school system, who's accustomed to not only picking up other folks' children, but taking your own child on a school bus to school each and every day. Your child who loves school. Testimony has been that he was nothing but a good and respectful child. And your child who you have gotten into a routine, a responsibility of notifying his parents or family members whenever he is not going to be home at a certain hour or doing something, but at least notifying the family, hey, this is where I am. And you as a parent, you do what you're supposed to do as the caretaker for that child. You get on the phone with his father. Hey, have you heard from Kendrick? No. Get on the phone with his sister. Get on the phone with his brother. Have you heard from Kendrick? No. Then you get on the phone with the police. You dial 911. My child didn't come home. You have the police officer come out to your home, you give him information, and then you get in your car and you drive out to the school everything that was said, everything that was done, it resulted in a refusal to allow not only the mother, but the grandparent, the aunts, and even the siblings from seeing their child, their loved one, their brother. Now that's got to be a very traumatic experience. You're faced with disbelief that it could at all be real. And you are wanting some satisfaction of knowing for yourself that this, that you had never ever thought would ever happen. I need to know if it's true. One of the things that they were told as the reason why you can't see Kendrick was because it's a crime scene. But shortly thereafter, what was beginning to, in the day that followed, in the newspapers that ran, in the news reports that ran, something that contradicted what you had been told as the reason why you couldn't see Kendrick. You were told it was because it was a crime scene. But what was told the public was, well, we found no evidence of foul play. So, no evidence of foul play. You're saying no evidence of a crime, but you told us a moment ago that it was a crime scene. Of course, you recall the testimony of Mr. Jones about when he learned from the EMTs that the EMTs had regarded it as a crime scene. When the EMTs, who were the only medical professionals out there on the scene, said he noted a bruise on the right side of the neck. The family's getting this conflicting information. But what was most conflicting was the refusal to allow the family to identify the body, so that the family then conducted a rally outside the doors of this courthouse on that following Sunday. After Mr. Johnson had returned off the road and had called and spoken to people at the sheriff's office, told essentially your son's body is going to be sent up to Macon for an autopsy. They felt like, we got to get some answers. We got to find out what happened to Kendrick. We have to reach out. And in conjunction with that protest, they then have a news conference. News conference in which they said to all of the viewers, we are refusing to give anybody permission to take our son's body out of this county, even for an autopsy, until we first identify his body. sheriff then begins to compound the confusion, the distrust, the unbelievability of what was being given to them. It's an explanation for their child's death. When he says, Kendrick entered a rolled up gym mat feet first, bent over to pick up the shoe inside the hole, and got stuck. You will recall Mr. Johnson's testimony. Sheriff, that ain't possible. There ain't enough room. And then Mr. Jones chimes in. Mr. Johnson, but see, what you don't understand is that when you die, your body, your muscles get limp. And at that point, Mr. Johnson said he became extremely angry. Why, of course he would become angry, because you have to wonder at that point, what kind of fool do you take me to be, to accept that explanation? He felt insulted. Ms. Johnson, she confirms that yes, there was an argument. It was about that very point. So now you feel that not only have I not been told the truth, but am I now at the point where I must question, is the truth being kept from me? In the days that followed, their child's clothes were missing. They were getting no reports other than what they were reading in the papers and hearing through the media in general. Most of it was saying he died as a result of an accident, one created by his own doing. That after interviewing just 3 witnesses, we found out that they store their tennis shoes in the mats sometimes. And even though we had access to video from surveillance cameras throughout the school, video cameras located in the gym where the mats were that he supposedly interacted with, we had no images of him going into the mat. We had no eyewitness reports saying they saw him enter into a rolled up gym. So we've concluded, notwithstanding that, notwithstanding a total absence of evidence that that is in fact what happened, we're going to stand on based upon a theory that he fell inside a map that had a hole that was too small for him to do anything but squeeze into, to get a shoe when he could have easily pushed over the map if that was something he was trying to do. That he got stuck, and in spite of it happening in the middle of a school day with over 3,000 students milling around, nobody saw him go into the map. Nobody heard him cry for help. Nobody saw a pair of legs dangling out the end of a map, indicating somebody was struggling to get out. The sheriff's department closed their investigation on that information. Now, suffice it to say that they didn't close their investigation until after the Johnsons had done a couple of things. Number one, they went out to the sheriff's department, heard Mr. Jones testify on at least 2 more occasions, trying to get information themselves as to who might be some of these students who you interviewed, who may have information. And you heard Mr. Jones say, well, you know, we couldn't give you the names of those students. Those children may have come and sat at my dinner table. Why are you protecting their identity when they may know what happened to Kendrick? They got on the phone. They called the G.B.R. crime lab up in Maine. When is this autopsy report? Okay. It's taking you all a while. Did the autopsy? What's taking so long? No answers. Then they got in their car and they went to the crime. No information, no results. And then they got on the phone and they called the U.S. Department of Justice. There was nobody else left. Not in the area of law enforcement. Sheriff, coming to you and saying, look, we're doing the best we can. We're exercising every resource that is available to us. And we're just having a tough time trying to pull it together. But that is not what we have here. They closed their investigation, saying that your son died as a result of the feelings that I just outlined. Now, again, they hadn't closed their investigation at the time as being April 25th, 2013. They had even less to work with at that time. They came here to this courthouse, consistent with what they had been doing the entire time before. They had been down on that street corner, holding signs with pictures of their child, before and after. Holding signs saying, all we want is the truth about what happened to Kendrick. Not we want revenge, not we want to find out who, we just want the truth. And when they could not get any reaction from those who are connected with this courtroom, the law enforcement community, they decided to engage in what's called civil disobedience. They came here to this courtroom saying that we felt justified in what we had to do because we were left with no other choice. That is why they are not here. And if there is any question in your mind in terms of whether or not what they did was reasonable, whether it was at all productive, what happened 7 days later? Well, on May 2nd, now, after months, the autopsy materialized. According to Mr. Jones, within a few days after that, a final report, investigative report from the Sheriff's Department materializes. Doesn't still get to the bottom of what occurred to Kendrick. But some progress was being made as opposed to what they felt was a situation that was going to be swept under the rug. And of course, they were hearing the rumors like everyone else. They were hearing about the bellboys. They were hearing all of this. And yet what they were hearing from the police, the law enforcement element of this community, the Sheriff's Department was, it was an accident. And as unbelievable as it may sound, he got stuck upside down in a rolled up piece of chicken. This family engaged in what I identified at the outset was an act of civil disobedience. Civil disobedience, some of us are more familiar with because of what we saw during the civil rights demonstrations and the anti-war residential streets, conducting sit-ins and things of that sort. But it predates that period well before the 60s. As a matter of fact, I went looking to find out what Henry David Thoreau, famous American author back in 1849, wrote about civil disobedience. And he said in that regard that civil disobedience is at least as old as Socrates, who preferred to die rather than yield to an order to stop asking questions. Was what the Johnson family faced with, was that tantamount to an order? Stop asking about what happened to your son. Just accept what we say to you. He goes on further to say, civil disobedience is at least as old as Socrates, who preferred to die rather than yield to an order to stop asking questions that embarrassed the authorities, to whom he said, I shall obey God rather than you. Henry David Thoreau engaged in civil disobedience when he refused to pay a poll tax as a form of protest against slavery. Slavery, which we have now since said is an unjust system and was supported by unjust laws. But you know, there was another act of civil disobedience that was and has been long revered as a beginning point for this very country itself. It's called the Boston Tea Party. What this family was engaged in, they were justified in. It was not an act of violence. It was an act of protest. It was designed to bring light onto a situation that was being covered in the darkness of confusion and misrepresentations and requests that people basically close their eyes to their common sense. It was their way of saying, wake up, Lowndes County. It's not that this ain't right. You know this ain't right. You know this explanation doesn't hold water. It doesn't make sense. And you might take the position, well, it's quite understandable why they might think that. They are the grieving parents. They are the relatives of Kendrick. And quite naturally, they they have that persuasion. Well, guess what? Apparently, there is some concern as to whether or not it is more than their suspicions as the kinfolk of Kendrick. It is also now the suspicions of the federal government, who since October of 2013 have been conducting an investigation of their own. If it was so simple what it is that the Lowndes County Sheriff's Department has concluded, why has it taken approaching better part of a year and a half, and they're still moving forward? And I think it interesting. I asked Mr. Jones, well, have they called you up there to testify? Somebody so central to the investigation. Something's not right. Don't know all the answers, but we know that it's not making sense. That's all this family has been saying. It's not making sense. But that's why it makes sense for us to do something, to try and bring to light the need for more scrutiny, more of an examination. We're willing to do what you want us to believe we'll never do. Justification, not nullification, justification. Not asking you to feel sorry for this family because they lost a loved one, because they got on the witness stand and cried, showed you their pain. Not because you need to feel sorry for them, but because they are doing something that is essential, absolutely essential to any civilized society. They petitioned government. They reached out to government in every way that they knew how to get the answers to a legitimate question that, quite frankly, every last one of us, our very safety, our very dependence, our very trust in government rest on their willingness to do their job and do it well. This is a courthouse of all the people, not some folk, of all. I heard Mr. Brown say more than a couple of times, oh, you were denying other folks justice by being downstairs. No, wasn't denying them. I was creating a situation where people would sit up and take notes. them got onto that witness stand and they testified as to the reason why they did what they did. They did not come here to interfere with anybody's right of access into this building. They came here to draw attention in the name of getting at the truth. The state's failure to prove criminal intent is reason enough, a reason by itself, which is sufficient for you to find that the state has failed to prove its case beyond a reasonable doubt. That in the name of justice, you will find them not guilty. Thank you.
Mr. Brown?
Mr. Chairman, thank you once again for your time the last 3 days. Back 3 days ago on Monday, when I asked each of y'all if y'all could sit on a panel and listen to the evidence and come to a very reasonable conclusion. Of course, I'm going to ask for a verdict of guilty. What that verdict is a verdict that speaks the truth. And the truth is that on April 25th, 2013, all 7 co-defendants broke the law. You heard all kinds of evidence about what may or may not happen with regards to the death of Kendrick Johnson. None of that's relevant. What you're here to decide is whether or not they committed interference with government property with charge of Wayne County Commission when they physically blocked individuals from coming into the courthouse. Now, Mr. King spoke about civil disobedience. Well, they have a right to practice civil disobedience. Johnson County's been doing that for a long time. They've been out on the street, nobody's bothered them, they testified, nobody's arrested us for that. They came up to the courthouse, they had rallies. A civil disobedience, you're allowed to do all that all day. Nobody's keeping them from doing that. It's a public building after all. But the minute you join hands and you lock hands and you stare people down and you don't let them in the building, that's when you break the law. That's the difference between civil disobedience and breaking the law. It's that simple. Mr. King even just said justice for all the people, not some folks. Well, you heard Ms. Whitlock. I even asked her when she got on the stand. I said, well, did you have any sympathy for the people you were keeping out of the courthouse? No, I didn't. Is that showing justice for all the people? No, it's not. And then, it seems like most of them would say, well, they could have gone around us. No reason people should have to go around you. You're blocking the courthouse. And Detective Jones, who's been so maligned by Mr. King for the last 3 days, do you see him on that video? We're going to play it in a minute. You see how many times he's asking them, y'all can't do this. This means block the courthouse. You can stand outside all day. You can protest. You can hold signs up. You can do all that. There's nothing wrong with that. That's their right. And God bless America for it, because in most places, in most countries, you can't do that. But it's when they broke the law, when they violated the law by blocking people out of the courthouse, that's what you're here to decide, guilt or innocence on. And Mr. King spoke about intent. Every one of them got up there and said they came up here to cause attention. The intent is in the action. When you block, and the deputy is telling you, can't do that, please stop doing that, that's when you commit the crime, that's when you're knowingly committing the crime, and you're intentionally committing the crime. So, they had knowledge, they had intent. Now, the judge is going to instruct you on reasonable doubt. What is reasonable doubt? Everybody watches TV. I have the burden of proof beyond reasonable doubt. A reasonable doubt is a fair-minded, impartial juror, honestly speaking the truth. That's what reasonable doubt is. It's not beyond all doubt. Well, heck, I proved beyond reasonable doubt. They admitted to doing it. They admitted to committing the crime. They admitted their guilt, but they're saying, well, we had an excuse. We had a reason. This was civil disobedience. This was not civil disobedience. This is not what Henry David Thoreau was talking about. The King read off his phone. Civil disobedience is when you don't cause any kind of physical intimidation to other people, but when you lock hands and you're staring at people and they're trying to get in, that's breaking the law. And you heard from Deputy Jones say They had set up an area inside the courtroom, in the courthouse, inside the rotunda. You could protest as long as you just don't cause disruption. You can't disrupt other individuals from doing what they've got to do, from going to their jobs, from getting a marriage license. That's the reason for interference with government property. That's the separation from just plain old-fashioned protesting, which the Johnson family has done for years now, versus committing a crime. And that's what you're here to decide. Not whether or not the death of Kendrick Johnson was, something was missing there or something wasn't done right. It's not what you're here for. You're here to decide the guilt of these 7 co-defendants on one count of interference with government property. Every one of them admitted to doing it. Every one of them. You think about the importance of a courthouse and what people do here. I work here. Tracy Chapman, Assistant DA, who prosecutes rapes. She was kept out of the courthouse. The lady that was behind her, Beth Danforth, she's an attorney here in town. She doesn't work in the courthouse, but she was coming here for something, and the lady behind her was trying to get a marriage license. Is it justice to block other people from doing what they need to do? And that's the intent of the law. They broke that law and they admitted to doing it. And I really enjoyed the part where they said, well, that we weren't blocking, y'all could have gone around. No. People in the courthouse should be able to come in the door that they choose to, not go around us because we've got something to say. Now I think almost every one of them that got on the stand, I said, well, did you protest the sheriff's office? Did you lock hands there? No. No. Go down to G.B.R. No. Didn't do anything there. What about making crime lab? What about Washington, D.C.? No. They chose to come to get attention here at the courthouse where the investigation doesn't even occur. This is not where investigations occur. That's where the sheriff's office, G.B.R., crime lab, that's what those places are for. They locked a room, a whole building, has nothing to do with the investigation of Kendrick Johnson. To get attention. That's what they said, to get attention. It doesn't excuse the fact that you broke the law and committed this crime. Stay admitted to doing it. I'm going to play to you a little bit of the first video that you've already seen. You can ask if they can see it. Times to try to say, please stop doing this or you're going to get arrested. Ample warning. Nothing to do with committing civil disobedience. It's the minute you broke the law. I just can't stress that enough. Stride also testified that none of them were arrested until they actually locked hands. They could have stayed out there all day. That was fine. So that's why you saw the different times of arrest. 2, and then I think Ms. Rowe a little bit later, and then 4 remaining inside by the where the security metal detectors. Nobody was arrested until they committed this act, which we're here for to decide. They had every right to protest. Nobody's stopping that. Ladies and gentlemen, like I said, I even agree that yes, the courthouse is a place of justice. And the Johnson's here, They want justice for their trial. They're sitting here, they got 2 attorneys. We've been here 3 days. But they don't mind blocking the courthouse, keeping other people from coming in and getting whatever they need done. Marriage license, probate, or will, look up the title deed. It bothered them, but they want their justice. So I'm going to quote what Mr. King said, justice for all people, but not just some folks. Well, they were keeping some folks that day from coming in the courthouse. And another thing, you say, well, it's no big deal, you know, they didn't really hurt anybody, and it was just 2 seconds. Well, y'all are the voice of the community. That's what a jury is. Y'all are the conscience of Lowndes County. Is this what you want? Is this what you want? Y'all are the voice, you 6 individuals, and every one of them got up and admitted to committing the crime. Reasonable doubt, intent, that's there. So I'm going to ask you to find all 7 of them guilty, 1 count each for interference with government property. Thank you.
All right, ladies and gentlemen, it's just about noon, and the charge of the court will probably be quite lengthy. So I think I'm going to let you take your lunch hour so that you can listen to the charge of the court on full stomach, and then you'll get the case. So it's 10 to 12. I give you all 1. Is that long enough? All right, very well. Let's be back at 1 o'clock. Let everyone remain seated while the jury retires. Ladies and gentlemen, are we ready? Let everyone remain seated while the jury returns. Bring the jury back, please. All right, ladies and gentlemen, you are considering the case of the state of Georgia versus Jacqueline Johnson, Kenneth Johnson, Barbara A. Jones, Tisha T. Marshall, Keisha A. Moore, Anastasia M. Rowe, and Lydia M. Whitlock. The Solicitor General has filed accusations charging the defendants with the offense of interference with government property. These accusations read as follows. In the State Court of Lowndes County, State of Georgia, on behalf of the people of the state of Georgia, the undersigned as prosecuting attorney for the county and state aforesaid, does charge and accuse Keisha Andrea Moore, Anastasia Marie Rowe, Lydia Marie Whitlock, Jacqueline Laverne Johnson, Tisha Lakeisha Marshall, Kenneth Lamar Johnson, and Barbara Ann Jones with the offense of misdemeanor interference with government property for the said accused in Lowndes County, Georgia, on or about the 25th day of April 2013, then and there unlawfully, in that the said accused did knowingly, willfully, intentionally, and without authority, obstruct the passage into or from government property, to wit, the Lowndes County Judicial Complex, the property of the Lowndes County Board of Commissioners, by using his or her body to block the doorway to citizens attempting to either enter or exit the building, contrary to the laws of said state, the good order, peace, and dignity thereof. And that's signed, Justo C. Cabral III, as Solicitor General of the State Court of Lowndes County. The defendants have entered pleas of not guilty to these charges. The charges and the pleas form the issue that you are to decide. Neither the accusations nor the pleas of not guilty should be considered as evidence. The defendants are presumed to be innocent until proven guilty. The defendants enter upon the trial of the case with a presumption of innocence in their favor. This presumption remains with the defendants until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendants are guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the accusation and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendants whatsoever, and the burden never shifts to the defendants to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is the doubt of the law, and you must acquit the defendants. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendants. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendants. Facts and circumstances that merely place upon the defendants a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendants. A jury is not authorized to find a person who was merely present at the scene of the commission of a crime at the time of its perpetration, guilty of consent in and concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in the actual perpetration of the crime, or participated in the criminal endeavor. A jury is not authorized to find a person who was merely associated with other persons involved in the commission of a crime, guilty of consent in or concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person helped in the actual perpetration of the crime or participated in the criminal endeavor. It is my duty and responsibility to determine the law that applies to this case and to instruct you in that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented. Then you must apply the law that I give you in the charge to the facts as you find them to be. The jury must determine the credibility of the witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including the witness's manner of testifying, their intelligence, their means and opportunity of knowing the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. Whether or not a witness has been impeached is an issue solely for you, the jury. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but means simply the intention to commit the act that is prohibited by a statute. These defendants will not be presumed to have acted with criminal intent, but you may find such an intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that the acts of a person of sound mind and discretion are the product of that person's will, and a person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make any such inference or inferences is a matter solely within the discretion of the jury. Your oath requires that you will decide this case based on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits admitted during the trial. Evidence does not include the accusations, the plea of not guilty, opening or closing remarks of the Solicitor General or defense counsel, or the questions asked by the Solicitor General or defense counsel. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as personally observing or otherwise witnessing that fact. Circumstantial evidence is proof of a set of facts or circumstances that tend to prove or disprove another fact by inference, that is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight you may give to either direct or circumstantial evidence. By way of example, if a witness testifies that he saw it snowing, then that would be direct evidence of the fact that it snowed. If no one saw it snowing, but the ground is covered with fresh snow, then that is an indirect or circumstantial evidence that it recently snowed. You would be authorized to convict only if the evidence, whether direct or circumstantial or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. These defendants are charged with a crime against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act or omission to act and intention. I charge you that a person commits the offense of interference with government property when he or she forcibly interferes with or obstructs the passage into or from government property. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendants, Jacqueline L. Johnson, Kenneth L. Johnson, Barbara A. Johnson, Tisha A. Marshall, Keisha A. Moore, Anastasia Rowe, and Lydia M. Whitlock in Lowndes County, Georgia, did on or about April 25, 2013, commit the offense of interference with government property as alleged in the accusations, you would be authorized to find the defendants guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendants are guilty of this offense, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendants, in which event the form of your verdict would be, we, the jury, find the defendants not guilty. Though you may consider the evidence as a whole, conviction of one defendant does not necessarily require the conviction of another or all. You, the jury, must determine the guilt or innocence of each defendant separately. You are only concerned with the guilt or innocence of the defendants. You are not to concern yourselves with punishment. One of your first duties in the jury room will be to select one of your number to act as foreperson who will preside over your deliberations and who will sign the verdict to which all 6 of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if convinced that it is wrong. However, you should never surrender an honest opinion in order to be congenial or to reach a verdict solely because of the opinions of the other jurors. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice for or against either party. By no ruling or comment that the court has made during the progress of the trial has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendants. Whatever your verdict, it must be unanimous, that is, agreed to by all. The verdict must be in writing and signed by one of your members as foreperson, dated and returned to be published in open court. All right, ladies and gentlemen, there are 7 accusations, each charging each of the 7 defendants. On the back of each accusation, there is a place that says verdict. It says, we the jury find the defendant. And then there's a blank and a place to be dated and the foreperson to sign. As I have stated, you must consider the guilt or innocence of each defendant separately. So for each of the 7 defendants, you must return a separate verdict. And you would write in on the back of the accusation, we the jury find the defendant. If you find beyond a reasonable doubt that the defendant is guilty of the offense, you would write guilty. If you have a reasonable doubt as to the guilt of the defendant, you would write, we the jury find the defendant not guilty. As I have said, you must return a separate verdict for each of the 7 defendants. You may now retire to the jury room, but do not begin deliberations until you receive the accusations and any exhibits that have been admitted in the case. All right, now it's Mr. Denson, all right? All right, Mr. Denson, I'm afraid that here's why I have to separate you off from the others and put you in a room by yourself for a little while, but we're not mad at you. All right, bailiff, you may escort the jurors, the 6 jurors to the jury room, and Mr. Denson to a separate place. Are any exceptions to the charge from the state, from the defense?
Except as to the non-inclusion of the charge on justification.
The objection is noted and continuing in nature. All right, now they get the accusations. Do y'all want those 3 discs to go to the jury room?
There's no way for them to be replaced.
Well, I understand. They were admitted evidence as exhibits.
Your Honor, we're satisfied that the accusation is
Okay, then I think that's all they get, are the accusations. All right, we will stand in recess while we await the jury's verdict. Okay, all right, now, ladies and gentlemen, it's my understanding the jury has reached a verdict. Regardless of what the jury's verdict is, I would like to maintain the decorum in the courtroom, please. So if you could please restrain your, regardless of what the jury's verdict is, if you could please restrain your emotions, I would appreciate it. All right, anything else we need to take up? All right.
nothing but
ladies and gentlemen, have you reached a verdict? Yeah. All right, if you will hand the verdict to the court, to the bailiff, and the bailiff will hand it to me. All right, State of Georgia versus, all right, let the defendants rise, please. All right, State of Georgia versus Barbara Ann Jones. We, the jury, find the defendant guilty. State of Georgia versus Keisha Andrea Moore. We, the jury, find the defendant guilty. State of Georgia versus Anastasia Marie Rowe. We, the jury, find the defendant guilty. State of Georgia versus Lydia Maria Whitlock. We, the jury, find the defendant guilty. State of Georgia versus Jacqueline Laverne Johnson. We, the jury, find the defendant guilty. State of Georgia versus Tisha Lakeisha Marshall. We, the jury, find the defendant guilty. State of Georgia versus Kenneth Lamar Johnson. We, the jury, find the defendant guilty. All right, you wish to examine the form of the verdict, Mr. King?
Yes, sir.
All right, you may be seated, ladies and gentlemen.
And are we entitled to have the jury?
Yes, sir. All right, ladies and gentlemen, I call your name. If you stand up, please. All right, sir, is this your verdict?
Yes.
Was it a free and voluntary verdict?
Yes.
Is it still your verdict?
Yes.
All right, thank you, sir. That's sufficient, Mr. King?
Yes, sir.
All right, ladies and gentlemen, I would like to thank you for your service to Lowndes, to your county and state this week. I know that it has been quite a sacrifice for you all to come up here and spend 3 days with us. But jury service is very important. It's critical to our democracy. The founding fathers of this country believed that the right to a trial by jury was just as important as the right to vote. And as a matter of fact, the revolutionary leader Patrick Henry once said that I hold that the right to a trial by jury is more important than the right to vote. So I thank you, ladies and gentlemen, for your service this week. And they should be receiving their checks in the mail in a couple of weeks. And I will excuse you at this time with the thanks of the court. All right, let everyone remain seated while the jury retires. Let everyone remain in the courtroom until the jury clears the building. All right, we will take a recess before we commence sentencing hearing, once the jury's had time to clear the building, Mr. Sheriff, people may move freely about the building. I'd say we'll have let's just plan on having the sentencing hearing at 3 o'clock. It's now 25 till. So let's plan on having the sentencing hearing in 25 minutes. Okay, once the jury's cleared the building, Mr. Sheriff, everybody's free to move around at will. I just don't want anybody, you know, I want the jurors to be able to get out.
Yes, sir.
All right, we'll stand in recess till 3 o'clock.
He come to transport it back to the county.
Transport all of them?
All right, we got everybody. All right, we ready?
Defense is ready, Your Honor.
All right, state wish to offer any evidence in aggravation. Yes, sir. All right, there's no other evidence in aggravation? All right, any evidence in mitigation?
Yes, Your Honor. Does the court prefer that it come in the form of testimony from each of the accused, or is this something that we can basically summarize by virtue of prior testimony?
I'll allow you to state your place, that'll be fine.
Yes. If I may have just 1 minute.
Yes, sir.
satisfied with my making on their behalf a statement to the court that the court we were requesting received in mitigation of any proposed sentence that is allowable under these circumstances. The court, of course, has heard the evidence, and I think that if there was anything that the court should focus upon is the element of intent. In instances where people are charged with criminal violations, you generally find there to be a motive that in and of itself may not be illegal, but you might consider to be selfish. That the person was moved without concern for the welfare of others. And in those instances where one is acting selfishly, as in a relationship that may be romantic in nature, and people become consumed by their love and affection for some person, they may engage in some kind of criminal act. This, I think, has been a case in which you have a hybrid of the two. It is a hybrid by virtue of very clearly there being evidence of a family's love for Kendrick Johnson, a youngster who, by all descriptions, was deserving of anyone's love. A well-mannered child who was outgoing, and a youngster who, as some describe, always was in a happy mood. That this youngster should have his life taken from him at such an early age. You can imagine for the family members, the very individuals who've been on trial here, was a very painful event. And they, like anyone, tried to rise to the occasion of not only coping with that pain, coping with that loss, but trying to also act in a constructive manner. I say constructive because wanting to know the truth of how he lost his life should be a concern of everyone. Wanting to put the parents and his brother and his sister in a position of knowing that though they couldn't reverse this offense or this event, that there at least was a rational way in which they could embrace it. Now, I think that you could take what my clients have done and extend it beyond the circle of the family, this constructive endeavor that they were engaged in. one which expressed itself in the many questions that were raised about the investigation into how they lost their son. Certainly, I can only imagine that many parents became equally as concerned because they have children who they give to the care and supervision of the school system on a daily basis and want to know and feel confident that when their children go to school, they will come back home safely to them. What these 7 individuals have been charged with by their own testimony was moved out of a concern and having reached a point at which their only motive was to get and bring attention to Kendrick's death and what dissatisfaction they had or unwillingness they had in accepting the explanation or the absence of information coming from the sheriff's office and whoever else may have been involved. They did so through civil disobedience. They did, in a very technical way, violate the law. But when the court focuses upon their intent, it was not an intention to harm any individual. None of the individuals who we saw in the video were any more than victims that were inconvenienced, but for a few seconds. No property was destroyed. No defacement of the building occurred. Nothing other than a form of protest that was calculated to get the attention of the sheriff's department. Now, we ask that the court take into consideration a couple other things. These individuals were all arrested, and but for Ms. Jacqueline Johnson, who had a medical condition, the 6 others were detained and were incarcerated there at the Lowndes County Jail until a bond could be set, which was on the following day. It may have been a day and a half, thereabouts, that they actually spent locked up. But we certainly don't think that that's something to be ignored. Whatever may come about as a result of being a person who's been convicted of this offense, that, of course, is still a price to be paid. We also ask that the court take into consideration that my clients are not wealthy folk, nor have they engaged in a pattern of behavior that I think deserves any huge amount in the way of a fine as a penalty. What we ask that the court take into consideration is the pain and suffering that they have endured since January 11th, 2013. The pain and suffering that they will continue to endure until that time comes when the truth of what happened to their child is finally disclosed. That is a penalty far above and beyond anything that this court could impose. We ask that you take all of those observations that I've just made into consideration, and that we ask that the court be just in its sentence.
Thank you. Mr. and Ms. Johnson, I would like to say to you that I am deeply sorry for the loss of your son. And I sincerely hope that you received the closure and the answers that you're seeking. This incident occurred almost 2 years ago. We're in January of 2000, end of January of 2015, and the case that we've been trying involves an incident that occurred in April of 2013, so we're just a few months short of this being 2 years ago. There have been no other incidents of this type. I believe that the interests of justice are best satisfied by the imposition of a suspended sentence in this matter, and I will sentence each of the defendants to 12 months in the Lowndes County Jail, which sentence will be suspended on the condition that the defendant shall not block or obstruct the entrance to any government building, and the defendant shall not otherwise violate the laws of any governmental unit. And my understanding is that the only difference between a suspended sentence and a probated sentence is that under a suspended sentence, you don't report to a probation officer, you supervise yourself. So essentially, don't get arrested again for a year. If there were to be another incident, the solicitor, within the next year, the Solicitor General could file a petition to revoke your suspended sentence and schedule a hearing. And I assume, since the Lowndes County judges have recused themselves and I'm assigned to this matter, that I guess I stay with the case for the 12 months. We would come back up here and have a hearing, and at which time, if it was necessary, I could incarcerate somebody. So we don't need to have any more arrests or any more incidents. I have prepared a sentence which, Mr. Brown, I'll ask you to. I prepared a sentence with a certificate of service. I'll ask the Assistant Solicitor General to sign. Mr. King, if you'll sign as a defendant's attorney, each defendant individually. Then Ms. Walker will make copies of the sentence, and once you have been served with a copy of your sentence, you have a right to appeal your conviction and sentence to the Court of Appeals of Georgia for the correction of any errors made during these proceedings. If you wish to appeal, you must file an appeal or have your attorney file an appeal within 30 days of today's date. Otherwise, you will have lost that right. Let me further advise you that you have 1 year from today's date in which you may challenge your conviction by the filing of a petition for a writ of habeas corpus. All right, gentlemen, if you all can get the signatures on these and the originals will go to the clerk, and Ms. Walker will make the
King. So first off, if you will, tell us your thoughts on the decision that was reached here today.
Well, we're certainly disappointed at the jury's verdict. We had hoped that the jury would have understood that the Johnson family had no intentions other than to bring attention to the tragic death of Kendrick Johnson, and as a consequence of which, that the family would have been immune from prosecution simply because they had no other choice. They had petitioned government on any number of occasions in any number of different ways, and to no avail. No response ever came from any of these governmental entities that was explanatory of what happened to Kendrick Johnson. It was not that we expected them to have an answer on all levels as to what occurred, but it seemed as though what they were given as information was inconceivable, altogether difficult to believe, and totally unacceptable. So we decided that we had no choice, not only but to do whatever we could to get the attention of government, but also to even take this matter to trial, all in an effort to get at the truth of what happened to Kendrick.
And so we have a new judge here today. What are your thoughts on having the judge from Thomas County, since the Lowndes County judges have recused themselves? Do you think he did a fair job?
I thought that the job done by the judge was a very conscientious one. I think that he had every intention of being as fair as he could to all of the parties. And so I don't believe there's any criticism that could be leveled against Judge Mitchell.
And the judge also said that you guys have the option to appeal the sentence if you would so choose to do that. Do you guys plan to do that, or is that something you're even considering at this point?
Yes, we are considering filing an appeal. We do believe that there was at least one error that was committed during the course of the trial, and we do believe that it is worthy of appellate review.
And so are you happy then to know that none of your clients are going to be behind bars anytime soon for this case?
Oh yes, I am extremely happy that none of them will be incarcerated or will suffer any kind of financial penalty.
Attorney King, what do you feel was an accomplishment by these 7 people being arrested? Do you feel that what happened ended up in some documents being released from the Sheriff's Department?
Well, I think that the family would say to you that all that they've ever tried to do was to bring attention to an event that had not been fully explained, and certainly a reason given that anyone could accept. And to the extent that the trial that they have endured was just another step in that direction, to bring attention to the many unanswered questions as to what happened to Kendrick Johnson and why it is that all of these questions have persisted for so long. I think that this is just another step in that journey.
And given that, do you feel like this was would you consider this a win, though? Even though you didn't get the verdict you wanted, you still were able to bring more attention to the Kendrick Johnson case than otherwise would have been brought?
Yes, I definitely think that this was a win for us, because the more attention that we're able to bring to this matter, and particularly in light of the fact that we have not reached anywhere near a point at which somebody has the answers, that somebody such as a prosecutor is in a position to take any kind of action against someone if that is the determination that is to be made. But the more attention that we bring to this issue, the better chance we think we will have at getting the answers the family has been looking for better now than in 2 years.
Yeah, I don't need that. Lydia, those 2 inches made you trouble. Huh? Those 2 inches made you trouble. Stay there just another second, guys.
We did what we did for the sake of our son. We went to jail for my son, and we're willing to die for my son. That was our child. And nothing in the world that we wouldn't do for our son.
Oh, really?
Is that all y'all want to say? Okay. Yep.
What we did for the sake of our son. We went to jail for my son, and we're willing to die for my son. That was our child. And nothing in the world that we wouldn't do for our son.
This is kvci.blogspot.com, also the Ghetto Free Press, the state capital of the state of Georgia. It's all about KJ's death, and it's about justice and bringing change to Valdosta, Lowndes County, and the Southern Judiciary. People are here, and we are here. They're taking it to the streets.
Never again. We got an order of service. And to lead us off and to welcome us, let's welcome, because this is a movement about young people and for young people. To welcome us formally to this gathering today, let's welcome with a big thunderous round of applause, Brother Stephen Green. He's the president of the Morehouse chapter of the NAACP. Let's welcome him. No justice! No peace! No justice! No peace! We're here today because we, like Nelson Mandela, have found ourselves on a long walk to freedom. This long walk to freedom from Valdosta, Georgia, from Lowndes County High School has led us to the door of the state capitol. We gathered here today because we thought the door was a regular push and pull door. The more we push for justice, the more they pull back from us. Then we found out the door of justice is actually a revolving door. And as we keep pushing, the more information we keep finding out. We find out that the videos have changed. We found out that the stuff with newspaper, the more we keep pushing, the more we keep finding out. But as we keep revolving, we turn into a revolution. And on this Christmas season, we came to petition for a Christmas revolution. We came to ask the governor standing at the door, we demand a coroner's inquest now. We want you to change the death certificate now. We're no longer going to sit here, but we believe in another revolution that happened on Christmas morning when a young black man was born in not Valdosta, but was born in Bethlehem. And the government tried to keep him down, but he said, still I rise. And we came today on this Christmas morning to tell you all we want for Christmas is justice. Valdosta's been too naughty. All we want is justice. We know that God can do all things but fail. And to give us our invocation is that giant prophet crying in the wilderness from First Iconium Baptist Church. Let's welcome to this podium the Reverend Timothy McDonald.
My friends, no movement succeeds without God. Every struggle that we have been engaged in, at the forefront and the background, has been God. Whether we believe or don't believe, this struggle in Valdosta and across this nation will only be won with the presence and the power of Almighty God. Shall we pray? Oh God, you've heard the cries of your children. Your word said, suffer the children to come unto me, and forbid them not, for such is your kingdom. Our children are dying in the streets. Our children, oh God, your children are being murdered in the streets. Their blood is crying out to us who believe in justice, who believe in freedom, who believe that lies have been told in Valdosta, who believe that KJ demands justice for all of the KJs around this great nation. Today we stand in the shadow of this state capital, where our governor turned his back on poor young black males. We cry out today that this governor and this General Assembly will do right by KJ, his family, and all the other KJs, and Trevon and Brother Davises all around this nation. Oh God, we invite and we invoke your presence and your power right now. For we know that you were with Martin. We know that you were with Mandela. We know that you were with Hosea. We know that you were with Dr. Lowry, T.T. Martin. And God, we know that you're here right now. You were with the family of Emmett Till. You were with the family of those who died in Alabama and Mississippi. But we know today as we stand in solidarity, young and old, black and white, Jew and Gentile, believers and non-believers, that this cause is the right cause, and justice will roll down like waters, and righteousness thank you for your presence. We thank you for your power. We thank you for your anointing. We thank you for courage. We thank you for enthusiasm. We thank you, oh God, because we've already won this battle for KJ and all the KJ. Because if God be for us, who can be against us? Thank you for being with us. Thank you for holding our hands. Thank you for being with the family. Thank you for being with the attorneys. And we thank you, God, for young people who know how to fight. For young people who are not afraid to fight. For young people who love justice. For young people who love truth. For young people who will win, who will stand, who will sing, and yes, who will go to jail for justice and truth and democracy. Bless us today as we stand together, because we know and we affirm that if you are with us, no governor can be against us. No legislator, no sheriff, no law enforcement. We stand on your promise that if God be for us, who can be against us? Thank you. Thank you. In your name, we pray. And we receive your presence and your presence.
Yes, sir.
Amen.
All right.
Let the church say amen. Amen. The church is in you, right? Yes. When you do battle like this, a lot of the power that we need are going to come from state houses just like this one. And I'm just glad we got a few elected officials. There's a difference between a politician and a public servant. A politician takes all that he or she can. A public servant gives all that they can. We're joined today by a public servant. She is. And I said she is. Somebody say she is. She is. Because a woman can do everything and anything. We welcome to the podium. She is the chair of the Georgia Legislative Black Caucus. Let's welcome Representative D. Dawkins Hager with a big round of applause.
Right.
In the Old Testament, in the book of Malachi, the prophet asked the question, what does the Lord require of us? And it says that we should act justly, love mercy, and walk humbly before your God. Most of the time, people will not do what is just and right. We won't do it because of political expediency. But it is very just and right that we stand in the gap now for the Johnson family. When I stand here, I don't stand here just as the chair of the Black Caucus, which is the largest Black caucus of the nation, with 61 members. I stand here as a fighter of justice. Because it's one thing to be the largest Black caucus, and then it's another thing to be the most effective Black caucus. You can be large, but you may not be just. And so with responsibility of having a large Black caucus, we ought to be accountable. We have to be reliable. And we have to be the moral temperature of the General Assembly. And sometimes that's not an easy thing to do. But it's the right and just thing to do. So what do we have? A fact. Kendrick Johnson is dead. A fact. We don't know what happened. Fact. The governor has the authority to call for a coroner's inquisition. Fact. He's going to get it done. Why? Because those of us who are in the General Assembly, and most importantly in the Black Caucus, are going to push. Because we have the resources at our hand to push for this family. How then can you say you're elected to an office and you don't use all the resources, all of the tools, all of the things that come with the office unless you're using it to promote yourself? A child has been killed. Somebody's baby is dead. And we're not going to stop until we find out what happened to Kendrick Johnson. And so if it means we have to march, if we have to rally, if we have to protest, if we have to shut the Capitol down on certain days, just like they do in North Carolina on Mondays, then that's what we'll have to do. So, as a politician, I would say we'll push to find out what happened. As a mother, I would say I hope that we find out what happened. As a spiritual woman, I would say we would pray to find out what happened. But as a public servant, in this state, I'm going to demand that we find out.
Whoop, there it is! Whoop, there it is!
See, I told you she was a bad sister, didn't I? All right. Amen. We're joined by a number of media personalities, and nobody do it better than our brother from BET. Let's welcome to the podium to give us his insight, to give us his inspiration, to let us know why this moment is so important. Let's welcome Jeff, cousin Jeff Johnson from BET. Let's welcome him with a big round of applause.
I got off the plane for Baltimore this morning because I have 2 sons. And so often we hear mothers that step up, but the media doesn't often show the fathers that are on the front lines. And there are men all over this country who have had enough, just like mothers. There are fathers who have had enough. Amen. Fathers who have had enough of black-on-black crime. Fathers who have had enough on black brutality. But they've had more than enough of seeing black boys in places where they have been brutalized by people that don't look like them, who want to shove it under the rug. And so as so many others will call and come for justice, I want to do something a little different. I want to speak directly to this governor. And I want to speak directly to this governor about who he is. Because we understand what his resume is and just want to remind him of where he's come from. We understand that you went to law school so that you understand what justice is supposed to look like. We understand that you served 4 years in the U.S. Army and know what it's supposed to look like when you fight for those that can't fight for themselves. We understand that when you get the title of captain, then that means you're supposed to lead others who often don't know how to lead themselves. We understand that you've been a juvenile court justice and a circuit court justice, which means you know when people don't get justice and when people do. We understand that all of these things were who you were before you ever got into this office behind us. And we say if governor means anything to you, then stand on the legacy of all the titles and positions that got you there in the first place and allow justice to come forward, for this young man is not getting it anywhere else.
Bring it now, bring it now.
Because it's time for talking is over.
Oh yeah.
That's right. This was a young man that wasn't out on the street. This was a young man that wasn't in the wrong place doing the wrong thing at the wrong time. This was a young man that was supposed to be in a place that was safe, in his school, supposed to be in a place where people looked out for him. And at every single step before and after his murder, there have been those that would attempt to say that he was in the wrong place at the wrong time, that he accidentally hit himself in the head and climbed into a mat. That all of a sudden the cameras don't work the way that they're supposed to. That all of a sudden his organs can be missing when nobody knows where they are. All of these issues speak to the fact that there is a cover-up in Loudoun County, and we need to figure out what that cover-up is. And so if you believe in this, speak to the governor about who he is. Roll on this county, roll on every state official until they understand that injustice anywhere is truly injustice everywhere.
Yes.
Yes. This is not a racial issue. This is not an economic issue. This is not poor against rich. This is not white against black. This is not city folks versus rural folks. This is simply about the truth. And so if we do not have a coroner's inquest come forward, then the truth continues to be hidden under a veil of nonsense. Let us talk reasonably and see the truth come forward. Otherwise, all of these folks in these positions are nothing but hypocrites. They are allowing a young man that did nothing wrong to die in the secrecy of protecting someone that needs to be brought to light. God bless you, and let's keep fighting together.
All right.